morning. The Senate Judiciary Committee will come to order. Want to thank everyone for their attendance today. And we have the honor of, on our first item on the agenda, is a hearing on HCR 5022, proposing a constitutional amendment requiring that a sheriff be elected in each county, with one exception. It's a very important issue that we will hear from the reviser on as far as the nuts and bolts of the amendment and how it would work. And we will then first hear from the reviser, Mr. Thompson. Thank you.
Thank you, Madam Chair, and good morning, committee. House Concurrent Resolution 5022 was requested by Representative Barker in Fed and State Committee, went through the Federal and State Affairs Committee, and then passed the House 97-24. So with that procedural background of how it got to you here, we'll turn to the nuts and bolts, as the chair mentioned. This does propose a constitutional amendment requiring that a sheriff be elected in each county. I noted in my bill brief that the current law is KSA 19-801A, and that provides that except in those counties operating under the provisions of any Consolidated Law Enforcement Act, beginning with the general election in 1976, a sheriff shall be elected in each county for 4 years. So the current law has this requirement unless there are counties that have opted out. And as most of you know, and as you'll hear from the conferees, there is one county, Raleigh County, that has opted out, and we'll have that discussion at the appropriate time. The concurrent resolution proposes an amendment to sections 2 and 5 of Article 9 of our Constitution of the state. It would make the office of county sheriff a constitutional office. Each county would be required to elect a sheriff for a term of 4 years, beginning at the time of voting designated by law for that office that was in effect on January 11th of this year. I understand from the House hearing that there are maybe 2 different election dates. There's one election in a certain county, and this would preserve that timing, and then elections in other counties would be on the timing that they've been on as well. And those elections would occur every 4 years. The requirement would not apply to any county that abolished the office of sheriff prior to January 11th of this year. So the one county, Raleigh County, that we referred to, this would not apply to them, but it would apply to every other county that has not opted out as of that date. The other amendment is in Section 5 of Article 9 to provide that a county sheriff could be removed from office only by a recall election or by a writ of quo warranto initiated by the Attorney General. So those are the only ways that you'd be able to remove a sheriff. And I'll remind the committee, as with all of our concurrent resolutions, you've heard a number of them over the last 2 years. It requires a 2/3 vote by both the House and the Senate to place this on the ballot before the electorate. If it's adopted by that majority, it would be on the November 2022 general election ballot, unless you call a special election at a sooner date. I'll stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Yes, Senator Thompson.
Thank you, Madam Chair. Thank you, Mr. Thompson. Just want to make sure if we pass this, then no county can try to appoint a sheriff. We want to make sure they are elected. Does this give the county any fudge room, any wiggle room at all in that regard?
Mr. Thompson?
Madam Chair and Senator, my understanding is that this would make it a constitutional office, and therefore it would have to be elected because that constitutional provision would control over any other law or constitutional provision.
Thank you. Thank you, Madam Chair.
Committee, other questions? Seeing none then, thank you, Mr. Thompson. And we will invite our first proponent in-person conferee, Greg Smith, Special Deputy Sheriff for Government, Veteran, and Crime Victim Affairs, Johnson County Sheriff's Office. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Always a privilege to be here. I'm Greg Smith. I'm the Special Deputy for Government Affairs for the Johnson County Sheriff's Office, and we are in support of the amendment. Just briefly, some history. There are 46 states that elect their sheriffs, and 40 of those do so on a partisan basis. There are 2 or 3 states that don't have sheriffs. There's one state that doesn't have any counties, so that obviously they don't have a sheriff. Sheriffs provide some important checks and balances in the law enforcement function. One, they are not beholden to an appointed body. They are beholden to the electorate. And they're not subject to the political whims of whatever that political body has. We feel that the citizens should have the right to elect their sheriff, and that really the election of the sheriff is the norm across the United States. It provides a stable and continuity in the office when you have an elected sheriff over those that are appointed. Those that are appointed obviously have to follow a certain agenda. There are two court cases I'd like to bring up just very quickly that support an independent sheriff, one being the Kansas Supreme Court case of Nylander. In that case, the Kansas Supreme Court made the statement that the sheriff is not a subordinate of the Board of County Commissioners. Secondly, in a U.S. District Court case in Kansas, Myers versus Brewer, the federal court pointed out that yes, while the county commissioners have the authority to approve the sheriff's budget, they do not have the authority to tell the sheriff how they expend that budget. And that really the powers of the sheriff are coextensive with that of the legislature. And with that, I'll be happy to stand with questions.
Thank you, Mr. Smith. We'll hold questions until we've heard from all the proponent conferees. Thank you. Next, we will invite Sheriff Jeffrey Easter, Legislative Chair, Kansas Sheriff's Association. Please introduce yourself and welcome to committee.
Well, good morning, Chairman Warren and committee members. I'm Jeff Easter, the Legislative Chair for the Kansas Sheriff's Association. By far and wide, this is probably the most important bill that the Kansas Sheriff's Association has ever taken on. I normally don't read from my written testimony, but there was some misunderstanding in the House hearing, so I want to make sure and clarify any of those misunderstandings, and then also reiterate how important it is that this bill gets passed. So there's three goals to this bill: to preserve the office of sheriff consistently throughout the state of Kansas, allows the office of sheriff to be required by the Constitution, and assures appropriate ouster process for the office of sheriff. Why this is so important: it assures the citizens in every county of Kansas currently has an elected sheriff, and will continue to have a law enforcement official in every county that will be selected by the electorate. That's what we find to be most important with this bill. This resolution confirms voter empowerment. This resolution assures voters can continue to directly hold sheriffs accountable. We do not believe voters want to strip themselves of the right to vote for sheriff like what has happened in the past and attempts to do so currently. There's been past and current attempts to change the office of sheriff. Current charter commission in Johnson County is debating to eliminate the office of sheriff right now. Last year, Sedgwick County asked the charter commission statute to be revised to allow Sedgwick County to start looking at the possibility of eliminating elected positions. There's been other attempts by other counties to do away with the elected sheriffs in the past several years. The part about the ouster that's so important is it doesn't change the process whatsoever. That was the part in the House that got a little bit confusing when we started receiving questions. Currently, the local district attorney, county attorney, or attorney general initiates the civil ouster process. Conflicts have existed in the past on ouster proceedings conducted by a local elected attorney against a local elected sheriff. All this would do would move the responsibility of the ouster procedure to the attorney general's office only and take it out of the hands of district attorneys and county attorneys. It retains completely the current ouster causes. It does not change that whatsoever. What it does do is it preserves the office of sheriff for 104 counties that currently have a sheriff, retains current 4-year election cycle for each of the 104 counties and currently elect a sheriff. Amends Article 9, Section 2, County and Townships officers, and Section 5, removal of officers of the Kansas Constitution. Grandfathers in the current county, which is Raleigh County, that has a different structure, so it does not affect them whatsoever. What it does not do, it does not make the office of sheriff a state of Kansas office. Does not change any of the duties of sheriff, nor does it place those duties into the Constitution. Does not shift any liability to the state. Does not change the legal process of ousters except who can file the action. The Kansas Sheriff's Association strongly believes that sheriffs should be elected by the citizens they serve and not appointed by other elected officials or appointed by a governing body. The duties of sheriff are much different from the task and duties of a police chief. Duties of sheriff by Kansas statute include keeping the peace, administering tax sales, overseeing jail operations, conducting warrant and civil process service, and guarding the courtrooms, to just name a few. Police departments do not have those responsibilities statutorily. Therefore, citizens should have the right to vote for a sheriff in all 104 counties that currently have elected sheriffs. In closing and preparing this resolution, KSA has met with interested parties on this topic, including the Kansas Peace Officers Association, Kansas Association of Chiefs of Police, Kansas Attorney and District Attorneys Association, Kansas Association of Counties, and Kansas Attorney General, among others. We have incorporated many suggestions into the resolution that's before you. This is the most important endeavor the KSA has been involved in over the last several years. Too many agendas are eroding the office of sheriff, and it's time to allow the office of sheriff to still and always remain elected by the people. And with that, I will stand for any questions.
Thank you, Sheriff. Do we have any other proponent conferees in the committee meeting room or online? Seeing none, then want to also direct committee's attention that we do have proponent written only testimony from Derek Schmidt, Kansas Attorney General, Office of the Attorney General, that is in your committee folder. And with that, we will then open it up for questions. Yes, Senator Pyle.
A question for Jason. Jason, does this in any way change? So if a sheriff were to resign midterm, most counties now, the precinct people would replace them based on their party. Does this change that, or does that remain in place?
Thank you for the question for the revisor, Mr. Thompson.
Madam Chair and Senator, the change here is to the section of the Constitution that deals with county and township officers. So by changing to include them here, they would thus be treated like all other county and township officers. So the law affecting replacements and other issues would apply to them just like it applies to the other officers.
Thank you. Senator Thompson.
Just one quick question for Sheriff Easter, if he's got a second. Thank you for being here and appreciate your testimony. I understand this is happening in other states as well. Or could you, just for the committee members who may not be aware of that, what is happening in some of these other localities and what kind of results have they seen?
So,
Sheriff Easter, if you'll go ahead and introduce yourself again for those following along.
Jeff
Thank
Easter,
you.
Legislative Chair for the Kansas Sheriff's Association. Yes, sir. So we looked at what's around the Midwest. In the state of Missouri, the Office of Sheriff is mentioned several times in the state's Constitution, excuse me, but it's not ratified in the Constitution. However, in Colorado, Oklahoma, Arkansas, and there's one other, and I can't remember. It is ratified, exactly what we're asking for here.
I was more talking about the states where they are trying to appoint sheriffs and what kind of disastrous results are they seeing in those locations?
I couldn't answer that, although there is places that are starting to look at appointing sheriffs. Again, I think that's why you see the Midwest, what I just explained, why the Midwest is going this direction. So that can't happen here in Kansas.
Okay. Thank you, Sheriff. Thank you, Madam Chair.
Thank you. And Sheriff, I have a question as well. Do we have, to follow up on Senator Thompson's questions, do we have examples of what happens when we have sheriffs who are appointed rather than elected? Do we have examples of why that's a bad idea if it's occurring in Kansas or other states?
Well, the best thing that I can probably share with you is I came from a police department. I worked there for 24 years. And so that police chief isn't beholden to the elected people. They're beholden to whoever your city council is and mayor is and manager is. And so, especially in times like we've experienced over the last 3 years, they can have different agendas depending on their elected bodies. Whereas with sheriffs, we're elected by the people, so that's who we listen to when we make our decisions on those kind of issues. And so, I will tell you that the mask mandates, which were being thrown out a couple of years ago, en masse, the sheriffs across the state of Kansas said, that's not a criminal issue, we're not enforcing that. When we were being asked if we could enforce it. And the fact of the matter is, our constituents didn't want it enforced as a criminal aspect. We're not enforcing that. And so those are the type of things that is different when you are elected by the people.
Thank you. And that's an important point to make. And do we have any other questions for our sheriff or other conferees? Senator Corson.
Thank you, Madam Chair. One question for Jason, if I could. Jason, can you remind me, I'm just forgetting, in all the 104 counties that elect sheriffs, is it whether or not they run as a member of a party? Is that vary county by county, or do they all run as members of a party? I'm just forgetting what our current practice is. And then I had a quick question for the proponents.
We'll ask our revisor, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. I was just looking at 19-801A because that's what I had cited about the sheriff's election and their term, and I don't see it in there. I'll have to look a little further, and maybe some of the sheriffs in the room could have a better answer about how they're elected, whether it's partisan or not, if that'll help get the committee where they need and not have to wait for me.
Sheriff Easter.
Yes, sir. We are either Democrats, Republicans, or independents is how you can run for office. And so it's a partisan election.
In all 104 counties that have that?
Yes, sir.
Okay. Can I ask one more, Madam Chair? I have no problem with electing sheriffs. I think it's great. I just kind of give me your response on like kind of the local control home rule question of, because I could see an argument that folks should say, hey, we've got elected bodies. We elect them locally to make these decisions. If they decide that, this should be a appointed position, there should be some other way of selecting that person. One could argue that that's kind of a local control home rule question. Again, I'm not opposed to electing sheriffs, but I could also see that side of the coin, so to speak.
Well,
that it should be counties should be able to make that decision through their elected representatives, in the way that that county believes is in its best interest.
Well, the good thing about this particular resolution, it does have to go to the public for local rule. It's going to be on, if it's passes, it goes to the ballot for the citizens of the state of Kansas to pass. So it is going to local rule, which is the citizens, not necessarily just the governing body because of whatever they think on that particular day.
Thank you, Madam Chair. I appreciate it. And thank you for being here. Thank you for your testimony. Thanks for your service.
Thank you. Yes, Senator Haley.
Thank you, Madam Chair. And I don't know, I think it's more a point of information. Maybe our county is an anomaly, but I think we run, or our sheriff runs in Wyandotte County nonpartisan. We just did have an election. I don't recall his party affiliation because frankly, he's in the minority registration for the county. And so I just wanted to clear that up.
It's my understanding, Senator Haley, that, I've ran 3 times now and you have to pick an affiliation to be able to run.
I think maybe Wyandotte County, because we're a unified government. I don't know how they.
Wyandotte is different though, because Wyandotte is also where you're from. Yes.
Yes.
I was thinking Shawnee,
Okay.
but where you're from
Okay.
is different because they have a unified, they still have a sheriff, but they have a unified police department.
Yes, absolutely. And we're very proud of our new sheriff, Sheriff Soptic, who just was recently elected. Thank you, sir. Appreciate it.
Thank you. Committee, other questions? Seeing none, then we will turn to our neutral conferee. And before we do, though, if our sheriffs have to get back to being back in their counties and on duty, want to take the opportunity to thank each and every one of you and those who were not able to attend in person here today as well for their service and to serve and protect. And and it's an honor to work with you and with the Kansas Sheriff's Association, as we do on many pieces of legislation that come through this committee, and to give our law enforcement community more tools to work with to keep our communities safe. So thank you very much for your attention today. And please, you're welcome to stay and visit with the committee when we're adjourned, or come and go as you please. Thank you again for your testimony and for your support of this very important resolution to make sure that our sheriffs serve the people. And with that, then we will hear from our neutral conferee, Kurt Muldrup, Interim Director, Raleigh County Police Department. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. I am Josh Kyle, Administrative Captain of the Raleigh County Police Department. I'm here on behalf of Interim Director Muldrup, who was unable to make it. Apparently he had a vacation scheduled, and I get the short straw. I am the son of Captain Dana Kyle, who retired from the Raleigh County Police Department in 2000, and I am the grandson of the late Captain Byron Bud Kyle, who retired from the Kansas Highway Patrol in 1976. My family has continuously served the state of Kansas as law enforcement officers since 1949, and it is my privilege and honor to testify before you today. Again, I testify on behalf of Interim Director Muldrup, who unfortunately could not make it due to the rescheduling because of the weather. I testify as neutral on HCR 5022. This neutral position is an acknowledgement of the language in the bill's current form that allows the RCPD to continue to exist. And I'll say that again, this bill in its current form allows RCPD to exist. Otherwise, we may find ourselves deconsolidated. Like my father before me, I have served the citizens of Raleigh County through the Raleigh County Police Department for the past 31 years and can personally attest to the effectiveness of the consolidated law enforcement agency that has existed since 1974. The Raleigh County Police Department is a vision of a man by the name of Don Everett. Don was county attorney, and he noticed that the different law enforcement agencies in Raleigh County varied significantly one from the other. The level of training, the level of proficiency, the level of professionalism varied significantly between the different agencies, and he thought that there might be a better way, at least for Raleigh County. Later on, Don became a state representative, a House Majority Floor Leader, and a state senator. And in that capacity, he created legislation that allowed for the citizens of any particular county to vote to decide whether or not to create a consolidated law enforcement agency for their county. The citizens of Raleigh County voted in favor of consolidated law enforcement for Raleigh County. And after about a year of its existence, they voted once again in favor. In fact, there was more people that were in favor of consolidated law enforcement after it had existed for a year. This legislation creates what is officially known as the Raleigh County Law Enforcement Agency, or what is commonly referred to as the Law Board. The Law Board is comprised of 7 members and really acts as a citizen oversight board. It's comprised of city and county commissioners, citizens at large of both the city of Manhattan and the county of Raleigh, and the county attorney. We have found this to be a very effective way of performing law enforcement in our jurisdiction. It allows us to focus our assets. We fall all under one roof financially and with our buildings and with our equipment and with our offices. We also have no guarantee of our existence, as this bill in its original form proved. We know that at any moment we could find ourselves deconsolidated, and so as a result we find ourselves highly accountable to our constituents to provide high quality professional law enforcement, as is evidenced by the fact that in 1991 we became nationally accredited and have maintained national accreditation since that time. There's been quite a bit of talk about the removal of law enforcement from the daily whims of individuals' political agendas, and we have found that the consolidated law enforcement as it exists in Raleigh County has accomplished the same thing. We do not report to a city commission or to a city manager, nor do we report to a board of county commissioners or to particular commissioners or administrators. We report to the law board as comprised by law. And as a result, we find a certain level of independence that allows us to maintain a high level of professionalism while at the same time avoiding the pitfalls of the day-to-day political whims of individuals. In closing, should you choose to advance HCR 5022, I respectfully ask that the language in lines 19 to 21 on page 1 remain intact so that the will of the citizens of Raleigh County be preserved in the form of the Raleigh County Police Department under the direct control of the law board. And I stand ready for any questions that you may have.
Thank you. Appreciate that. And thank you for clarifying why you're here today, and appreciate you showing, and thank you for your testimony. Committee, do we have questions for the conferee? And before we get to that, let me ask, do we have any other neutral conferees in the committee meeting room or online? Seeing none, then we will go ahead and open it up for questions for our neutral conferee, if there are any. Yes, Senator Wilborn.
Thank you, Madam Chair, and thank you for being here, and thank you for your family's service over the last half century or more. Yeah, thank you. A couple of questions I have. I know Manhattan, K-State, do they have their own separate police department? They used to have when I was there. Is it part of the consolidation, number one?
Madam Chair and Senator, Kansas State University Police Department is separate and distinct from the Raleigh County Police Department. Now, we do have concurrent jurisdictions, but we are two separate and distinct entities.
I thank you. One more question, if I may, Madam Chairman. You talk about the oversight board that governs a little bit about this. Are they elected or are they appointed?
Excellent question. It's comprised of different members. There's city commissioners, and of course, they're elected. There's county commissioners, they're elected as well. And then the city commission and the county commission appoint citizens at large. Those citizens at large can be commissioners themselves, but they also are just required by law to be citizens of either the city of Manhattan or the county itself. And then, of course, the county attorney is the permanent member of the board.
Thank you. Committee. Yes, Senator Gossage.
Thank you, Madam Chair. Thank you for being here. Forgive my bit of confusion. So when you say consolidated, right, that if this were passed, then, and leaving in 19 to 21, you would not, am I using the term right? You would not be consolidated, or what was the term that you used?
Senator and Madam Chair, it's my understanding the way the statute or the House bill was constructed, that if it required Raleigh County to elect a sheriff, it would effectively undo the consolidation as it exists in Raleigh County. The mere election of a sheriff then would create a situation where the director of the police department, which is the title given, not chief, not sheriff, director, would effectively no longer be able to perform the duties of a sheriff. And therefore, the construction of consolidation in Raleigh County would no longer be allowed to exist because it would no longer meet statute.
So that is why in the constitutional amendment, it would say other than a county that doesn't have a sheriff. Is that why that's in here? Do you know?
We ask that there be language that allows Raleigh County to exist in its current form, law enforcement to exist in its current form. And I'm not certain I'm answering your question, and I'm sorry about that, but I think the language would need to be constructed in such a way that it allows Raleigh County to maintain the law enforcement that's existed since consolidation in 1974, and effectively not require it to elect a sheriff.
So in the bill itself, line 19, the provisions of subsection shall not apply to a county that abolished the office of sheriff prior to January 11th of 2022, which would be you, right? That Raleigh County?
I have to be a little bit careful and yield to those who are more knowledgeable about the law and the construction of the law. When I hear it, it sounds correct that it would allow Raleigh County to maintain its current form of law enforcement, but I have to be honest with you, I'm not absolutely certain the way it's worded.
So you are neutral because you just want to be sure this is going to do what it says it's going to do, and you guys can stay the way you are.
Yes, neutrality allows us to do two things. It allows us to maintain law enforcement the way it currently exists in Raleigh County, while at the same time, it allows us to remain in the good graces of our brothers and sisters in sheriff's departments across the state.
Thank you very much. Thank you, Madam Chair.
Thank you for that. I think Sheriff Easter can help answer the question there. Sheriff Easter, if you want to come introduce yourself again. Thank you.
The real quick answer to your question is yes. The language as it's written right now, as long as there's no amendments, allows for anybody prior to January 21st of 2022 to maintain their law enforcement model, which includes Raleigh County and also includes Wyandotte County.
Thank you. Do we have other, I asked already before, but do we have any other neutral conferees in the committee meeting room or online? And I don't see any. Do we have any opponent conferees in the committee meeting room or online? Not seeing any there either. Want to again, excuse me, we'll have a comment from our reviser, Mr. Thompson.
Apologies, Madam Chair. Thank you very much. Before you close the hearing, I just wanted to give one response to one of the questions that came up and be a little clearer. I was not able to find anything about partisan or nonpartisan, so I'll defer to what Sheriff Easter said to this point. I don't have anything that contradicts that. But in looking for that, I found one response to Senator Pyle's question about appointment to fill vacancies, and I just wanted to be clear on that because I'm not sure that I was right before. So there's a statute, KSA 19-804, that provides, and this would still be the law even if you adopt the constitutional amendment, that except in those counties operated under Consolidated Law Enforcement Act, whenever a vacancy occurs in the office of sheriff of any county, the undersheriff shall serve as sheriff until a sheriff shall be appointed by the governor in the manner provided by law for filling vacancies in the office of a member of the House of Representatives. So you have a current law that says any vacancy in the office of sheriff is filled by the governor, the same as a seat in the House of Representatives is filled. And I think earlier we were talking about a different county proposal, and I just wanted to clarify that.
Thank you for that clarification. Committee, do we have any other questions for the reviser or any of the conferees? Seeing none, then want to again thank our conferees and our sheriffs for appearing today and for your hard work for the citizens of the state of Kansas and to keep our communities safe. So thank you, and please visit with us anytime you have an opportunity to, or if we can help in any way. So with that then, committee, we will close the hearing on HCR 5022. Thank you, everyone. And we will now turn our attention to opening the hearing on House Bill 2608, removing provisions authorizing criminal restitution to be enforced as a civil judgment and authorizing judicial districts to contract for collection services for criminal restitution. With that, we will ask for a bill brief from our reviser, Mr. Thompson.
All right. Thank you again, Madam Chair. So House Bill 2608 is a bill that would remove provisions authorizing criminal restitution to be enforced as a civil judgment, and instead authorize judicial districts to contract for collection services for criminal restitution and provide a means for covering that restitution ordered. I'll note the procedural background. The bill was requested in committee by Allie Devine on behalf of Butler Law. I see Butler Law is here as a proponent. The House Judiciary Committee passed the bill, and then the House passed it out 117 in favor and 4 opposed. So the bill covers a number of sections, essentially to facilitate that broad policy of taking civil judgment enforcement of criminal restitution and moving that to a more specific term of recovering. There's a Kansas Supreme Court case that said the current way that the state was enforcing restitution through the civil process was unconstitutional. That left some question about what could be done to recover criminal restitution. I think you'll hear plenty about that from the proponents, so I won't get into it any more than giving you that sort of backdrop. We currently don't have the civil process that was in place is not allowed to be used anymore for criminal restitution, and this is the proposal to replace that system, essentially. So the First Amendment there in Section 1 is KSA 20-169. That's your statute authorizing the judicial administrator of the judicial branch to enter into contracts for collection services for debts owed to courts or for restitution owed under an order of restitution. The amendment is in subsection E. It provides that judicial districts are authorized to utilize the collection services of those contracting agents pursuant to this section to collect restitution owed under an order of restitution. So they'd be able to use those same contractors that are being used to collect other debts of the court under KSA 20-169. Section 2 then gets into the criminal code, KSA 21-6604. That's our statute that gives you all the sentencing options when a person has been found guilty of a crime. Subsection B2 has an amendment to clarify that garnishment as a method of collecting restitution shall be conducted pursuant to Article 7 of Chapter 60 concerning attachment and garnishment. That's one of the things that there was a problem with the current system that would be changed here. We'd have a direct reference to Article 7 and our Civil Procedure Code to deal with garnishment as a method of collecting restitution. Section 3 gets into the criminal procedure code. That's KSA 22-3424. And this amendment here would provide that orders of restitution are enforced under KSA 20-169, which I just explained to you in Section 1, and 21-6604 B2, which I just explained was Section 2. And that would be instead of the two current KSAs, 60-4301 and 60-4304. Those pieces were ruled unconstitutional. They are repealed by this bill. So it also repeals not only 4301 and 4304, but 4302, 4303, and and I think I have a typo in my bill, 604305. So you'll note that there are several sections repealed by the bill. Those are the ones that were deemed unconstitutional, and they're replaced instead by these couple of criminal provisions that I was just talking about. And I apologize, there is a typo in the bill brief. I'll try to get a corrected version out there. Just mistyped some numbers there. Section 4 then goes into the Civil Code. KSA 60-2310 changes a cross-reference related to those contracts that we were talking about for collection services. It currently references a KSA 75, which is the old number. It should reference the current number that was transferred to 20-169. So it's more of a technical cleanup, but I at least wanted to tell you why that section is in there. And then the final section is KSA 60-2403. That's dealing with undisputed payments made prior to a request for release of judgment. They're deemed voluntary and not subject to refund or recoupment. So that's more of a procedural matter when you get over to that. But I at least wanted to highlight that amendment is made there. And I believe this is also, I just want to make sure if it's this section or the other section. There's one other very small amendment that I believe you have some testimony on, very specific to just a couple of word changes. And I wanted to highlight where that was. I don't really want to get into it myself. Other than there's some policy issues maybe that you'll want to hear about from the conferees and maybe address. I just wanted to point out where the language is. And that would be on page 15. This is in section 4, KSA 60-2310. It's in line 23 of page 15. Earnings means compensation paid or payable for personal services. The paid or is struck. I didn't really highlight that in my bill brief. I don't know that I would have highlighted it other than I saw in the testimony that this is an issue that at least one conferee would like you to look at specifically, and whether that change should be made in this bill or if that's a policy change that you maybe need a little more information about. So I just wanted to point that out because it was a small change I didn't highlight otherwise in my bill brief. So I'll stand for questions if you have any.
Thank you, Mr. Thompson. Excuse me, committee, questions for the revisor? Seeing none then, we will invite our proponent, conferee Todd Butler of Butler and Associates. Please introduce yourself and welcome to committee.
Sorry. Thank you, Madam Chair. Members of the committee, my name is Todd Butler. I'm an attorney. I'm the principal for Butler and Associates, PA. We are a contracting agent pursuant to KSA 20-169. That statute authorizes the Office of Judicial Administration to select vendors who are then offered to the judicial districts across the state of Kansas to collect court debt, which is court costs, fines, fees, and restitution. Our office currently represents 13 judicial districts of the 31 judicial districts here in the state of Kansas. The districts we represent include Shawnee County, Johnson, Wyandotte, and Sedgwick, some of the larger districts here. In October of 2021, the Kansas Supreme Court issued an opinion in the case of State versus Taylor Arnett. In that decision, the Kansas Supreme Court found several statutes that we use to collect court debt and restitution to be unconstitutional. Specifically, those statutes we use to collect restitution. As a result of that opinion, the court found several statutes unconstitutional and we no longer can collect. The Office of Judicial Administration has asked for all vendors to close and return restitution debt. So in my particular office, we have 38,000 crime victims that we can no longer collect for. My estimate, not that of the revisers or anyone else, is that there's over 70,000 crime victims in the state of Kansas who can no longer recover for the injuries they received. Yet the Supreme Court found that the Kansas district courts can continue to order restitution. So this bill is our attempt to bring restitution back so that the contracting agents can collect for the crime victims across the state of Kansas. The financial note along with this bill provides that there are approximately $257 million in restitution orders. So what's happened is after an individual is released from probation and from prison, there is nothing that can be done right now to collect restitution. Zero. I cannot even accept voluntary payments. So what we've done is we've worked with Natalie Scott of the Revisor's Office and Natalie Chalmers of the Attorney General's Office, Solicitor General, and asked for their assistance in drafting a bill to bring the restitution back. We've determined there is nothing we can do under the Taylor-Arnett decision, the State versus Arnett decision, to assist the crime victims in collecting it on their own. As a part of that decision, KSA 60-4301 through 4305 was also found to be unconstitutional. That means that the crime victims can't hire their own counsel to assist them. And what's happened is most crime victims have been lured into the decision to let the state collect, the district attorney to get a finding of guilt, and the district attorney to get an order of restitution through the courts, and then it would be collected for them. And under KSA 20-169, the cost for the contracting agents is shifted to the criminal defendant. So there was no reason for the crime victims to do anything. Unfortunately, under Kansas law, most civil claims against the criminals for the injuries that they cause is barred after 1 or 2 years. So when the Arnett decision came out, that left no opportunity for the crime victims to recover for their injuries. So that's the result of this bill, is to try to bring it back. That's all. We can't do anything about giving the crime victims an opportunity to select their own counsel, but we can, I believe, under this bill, allow the crime victims to select any of the vendors that are there available, chosen from the Office of Judicial Administration. So the initial sections 1, 2, and 3 of the bill are for that purpose. That's their sole purpose. Section 4 is an amendment to KSA 60-2310 under the definition of earnings. There was a Kansas Supreme Court decision last year in the case of Stormontville versus Harold Sievers, where the court found that money paid by an employer into a bank account retained its exempt status because of the word paid or, the past tense in that word paid. That decision has the potential effect of eliminating bank garnishments because there's no time or limitation on that exemption. So anyone who has money deposited into their bank from their payroll, from their checks or direct deposit, that money would be protected indefinitely under that decision. So we're asking for the court, for the committee here, for this bill to return matters to the way they were pre-October 2021. Okay. Section 5, there was again a decision, Kansas Supreme Court, where KSA 60-2403 were asking to be amended. We had an individual who was ordered to pay $278 in court costs. And that individual paid his court costs over a long period of time. He was convicted in 1994. His payments were all made voluntarily. But unfortunately, the judgment for his costs was void at the time that he was making the payments. The time he was making the payments, he was still in prison. He was on work release. And so he made payments while in prison and while on work release. And several months later, he asked for the court to have the money returned because the judgment was void at the time he made those voluntary payments. The court ordered the $278 to be returned. If they're voluntary payments, we can't accuse or expect the clerk of the court to review all of the judgments to make sure that they are not void or voidable. And we're asking for the language here in order to protect actually the state of Kansas from having to return monies that are collected after judgments are void. That's all that I have with regards to this bill. There are, by my estimates, over 70,000 crime victims who need your help.
Thank you, Mr. Butler. We'll reserve questions till we hear from all the proponent conferees, and want to stand at ease for just a moment because I need to make sure my folder is complete on this bill. Just a moment. Thank you for that. I now have the documents that are part of the hearing today and want to let committee members know that we have proponent conferee written only testimony from Mike Kege, Shawnee County District Attorney, on behalf of the Kansas County and District Attorneys Association, as well as from Stephen Carrero, Deputy Attorney General, Office of the Attorney General. With that then, committee, we will open it up for any questions for our conferee. Senator Pyle.
Thank you, Madam Chair. I'm not sure who gets the question, but the Office of Judicial Administration is under contract to get those services for collection. What's their percentage? What's their take if that $260 million is collected?
Thank you. Is that something you can answer, Mr. Butler? If you know, please introduce yourself again.
Thank you, Madam Chair. Todd Butler. 1% is the current take with the OJA.
So that'd be roughly what? 2.6, nearly $3 million. And is that contract, when is that contract up for renewal?
The contract is up for renewal in July of this year.
Do you know if there's any negotiations to raise that percentage?
It's not a matter of negotiations. The Office of Judicial Administration can, I believe the statute says they can collect either from 1% to 3%.
Thank you.
Thank you. Senator Thompson. And just a moment, before we have further questions, want to first determine whether we have other proponent conferees in the committee meeting room or online. I didn't think we did, but just wanted to be sure before we asked further questions, and if we needed to circle back to your question, Senator Pyle, if we had other conferees. But seeing none, go ahead, Senator Thompson.
Thank you, Madam Chair. Thank you, Mr. Butler. One quick question on this, just so I'm clear in my mind. Do the crime victims get the full restitution, or does the 1% come out of their restitution, or does the state collect that fee from the perpetrator?
Crime victims are satisfied in whole. The criminal is responsible for paying the fee for the contracting agent and for the Office of Judicial Administration.
So if they were to voluntarily pay the court, they wouldn't have to go through that process of paying that fee, correct?
That's correct. If they pay voluntarily, they don't, before I'm hired, retained, they just pay the amount ordered by the court. And
thank you. Committee, other questions? I have a follow-up question to make sure that I'm clear that because of a Kansas Supreme Court decision, without this bill becoming law, Kansas victims of crime who, after a conviction of the defendant, don't have any means to enforce or actually collect on an order by a court for criminal restitution. Do I have that right?
Exactly correct.
And that means the Office of Judicial Administration cannot collect that criminal restitution, and neither can any private attorney. Is that right?
That is correct.
Would you think then that without this bill, if this bill doesn't become law, would courts even then order criminal restitution for Kansas crime victims anymore?
The court in decision affirmed the fact that the district courts can still order restitution. What happens is while they're in prison and while they're on probation, the probation officers can work to collect the restitution order. And the court can work to make sure that they pay while they're on probation. What the result may be is certain judges may never want to let any people off of probation. Because once they're off of probation, unless this law comes into effect, there will never be an opportunity to collect. Never.
And this is a recent Supreme Court decision. You said October 2021. So it looks like we have a response, an option to make sure that our crime victims can receive the restitution to help make them whole with this bill.
At the end of October, we were instructed to return all restitution files from our office and every contracting agent. So no one is collecting for the crime victims right now.
Thank you. Committee, other questions? Senator Gossage.
Madam Chair, this was passed by the House, is that correct?
It was 117 to 4.
Thank you.
If I have that
didn't see
right.
that. Thank you very much.
Thank you. Committee, other questions? Seeing none, then thank you, Mr. Butler, for appearing today in person and for your testimony. Appreciate being informed of this situation and that we have an opportunity to take some action to help correct it. Thank you. Do we have any neutral conferees in the committee meeting room or online? Not seeing any. We do have an opponent conferee in person who we will welcome to the podium, Marilyn Harp, Executive Director, Kansas Legal Services. Please introduce yourself and welcome to committee.
Thank you. I'm Marilyn Harp, Kansas Legal Services, Madam Chairwoman and committee. Thank you for hearing from me today. Please understand that I'm not here standing in the way of crime victims and restitution. That most of this bill is something that I would wholeheartedly support. However, in part in this bill, the proponents, Butler and Associates, are taking an opportunity to undermine on a policy basis something that has been long-standing law since the time of statehood, and that has to do with the change to a couple of words in Section 4, specifically page 15, line 23, where they propose to change Kansas law to say that that wages are money payable and not money paid. Succinctly, Kansas law, since for at least 70 years, has protected, and some say since statehood, have protected 75% of a wage earner's claim from garnishment. And that is in recognition that while people should pay their debts, they also should have some money set aside to meet their current obligations, allow them to pay rent, buy food, support their families. And so the garnishment law allows 25% of wages to be garnished and allows the wage earner to take 75%. A change has happened in the last 20 years, 30 years that you might recognize, and that is direct deposit of paychecks into a bank account. And so most earners can no longer avoid bank accounts for their wages. And what some collection firms have done is garnish 25% of wages on day one, wait till payday, and on day two, attach a bank account and receive the other 75% of the wages because it's in the bank account. The Supreme Court decided that the words paid and payable meant that that 75%, which has long been protected by legislation to avoid attachment, avoid garnishment, and allow families to meet their current earnings, would no longer be protected, would be protected. And this change that has nothing to do with restitution, but has to do with all bank attachments, all garnishments, to change Section 4 to remove the words pay to wages payable and paid, to return the and paid, will allow any attachment of a bank account to pick up all the wages, undoing on a policy basis the decision longstanding of this legislature to protect 75% of wages from garnishment and attachment. Now, Mr. Butler, in his testimony, claimed that there's no rules about this. But in fact, if a person subject to bank attachment, subject to collection, wishes to enforce this exemption, they must file a claim and have a hearing and convince a judge that money, how much of the money in the bank account is wages. We are often talking about people who live hand to mouth, who can show clearly that the money in their bank account is wages. And if they can't, the judge will deny their claim of exemption. It is not something that needs to be avoided by the collection agency or the person seeking payment of the debt. It is an exemption that a person must come before the court with records showing that that's wages and seek the exemption. So the single change that I am seeking in this, the single part of this I oppose, which you've heard from the reviser, is not part of the effort to seek restitution, and is not about restitution, but about the entire way that bank accounts are attached, is to strike page 15, line 23 in section 4, such that the bill moves forward without the revision and the removal of the paid or language on page 15, line 23. To fail to do that changes in law, changes the policy of garnishment and attachment that has existed for many years in Kansas law.
Thank you. Do we have any other opponent conferees in the committee meeting room or online? Seeing none, then we will open it up for questions for our opponent conferee. Committee, do we have any questions? Yes, Senator Baumgardner.
Thank you, Madam Chair. Thank you for being with us today, Ms. Harp. So did you provide testimony on this very matter to the House during their hearing?
We did not, because as you can see from the title of this bill, it appeared to be entirely about restitution. There was nothing that flagged this as undermining the entire basis of attachment of bank accounts. And so frankly, we missed it from reading the title to the bill, as I suspect you did, and as the revisor did when he said, you know, it did not include it in his bill summary because it appeared to be such a not a major policy decision until we raised it.
Thank you, Madam Chair.
Thank you. Could you, Ms. Harp, explain briefly for the committee and others following along online? You're here on behalf of Kansas Legal Services. If you could explain what that organization does.
Sure, Your Honor. I'm sorry, Madam Chairwoman, thank you. Kansas Legal Services is a statewide organization that a nonprofit corporation that's devoted to helping low-income and other vulnerable Kansans meet their basic needs. We provide legal services on their behalf. And let me also let you know that we were the opposing party in the Seavers case. We were the prevailing party in the Seavers case, the case that Mr. Butler indicates is the reason why they are seeking this change.
Thank you. Committee, other questions? Seeing none then. I'm sorry. Yes, Senator Bowers.
You go ahead.
And then Senator Thompson.
Thank you, Chairwoman. I'm curious to see what the proponent might suggest this change does to the bill. But I know we've passed the proponent timeline, but I would be curious to see if there's objection to this, at least if we move forward, if we want an amendment. Thank you, Madam Chair.
Thank you. Ms. Harp, have you had any discussions with any of the proponents, either written or otherwise, about this particular amendment you seek of the bill?
I have not. I would point out that there's nothing in the proponent testimony other than Mr. Butler about this change. Mike Kagi and the District Attorney's Office do not speak to this change in Section 4, only the changes about the restitution part of the bill, Section 1, 2, 3, and 5. They make no statements in support of the, and there is a technical change about the statute number in Section 4, but none of those proponents speak specifically to the paid or payable language.
Thank you. Senator Thompson.
Thank you, Madam Chair. It's Monday. My brain is still foggy from a weekend. I just want to make sure I'm clear on this. Paid seems to be in past tense, so money that they paid. I guess what I'm trying to figure out is, payable means whatever's coming to them for, work they performed, but paid would mean work that they'd already done and had been paid for, I'm assuming, after they'd been out of jail and working on the job.
So
just help me.
Okay, so you're viewing this in the context of the restitution claim, which it is not. This claim, this change affects every person who is who for whom garnishment or attachment of wages is possible. Every person, not simply people paying restitution. That's why this is buried in here and hidden, and we didn't testify in the House, because this is every person that any collection agency goes after. In fact, you'll notice that the court case that this came out of is a hospital collection case, not a restitution collection case by any means. So the law currently says wages for which there is a protection of 75% means both wages payable, which applies to people who are being garnished, and wages paid, which would mean paid into a bank account and subject to attachment, which is the other way debts can be collected. Both garnishment of wages and attachment once it reaches a bank account. And this change would remove the protection of wages once they reach a bank account, which we all know happens by direct deposit to almost all of us.
Okay, that clears it up.
Thanks.
Like I said, it's Monday.
Yeah.
Thank you.
Thank you. Yes, Senator Gossage.
Thank you very much, Madam Chair. I'm trying to follow, I'm on page 17 of the bill,
Okay.
and it has 50% specified in paragraph 1, shall be 55%, 60% specified in paragraph 2, shall be 65%. Could you direct me in the bill where it talks about
If you had flipped to page 15
15?
and line 23,
Mm-hmm.
it defines earnings as compensation, and the proposal is to take out paid or, and simply say compensation payable. The percentages, just to help with the confusion, because I've been talking about 25%. Kansas law allows a greater percentage of wages for people who owe child support. And the reference you made on page 17 are the greater percentages that can be garnished for people who owe child support. Traditionally, 25% for people who owe other debt.
And perhaps I missed this question, but did you give this testimony in the House as well?
We did not. It was not raised. And as I said earlier, this little change is buried in a bill titled Restitution, and which, as you heard from the reviser, he did not even include in his bill summary because it seemed like a small thing, when in fact we're trying to raise to you the issue that this is a huge change to all garnishment law and not merely a change with regard to restitution or crime victims, because this definition applies not just to crime victims, not just to restitution, but to all garnishments, all bank attachments for any creditor and any debtor in the state.
So you are not opposed to the rest of the bill, but just this paid for
Right.
section?
Right, not at all opposed to the rest of the bill. I think we represent a lot of crime victims as well in protection from abuse actions, for example. I'm not standing in the way of restitution in that regard in any way. Merely this major policy change about paid, that removes the paid language.
Thank you, Madam Chair.
The committee want to draw your attention to the supplemental note. The supplemental note, after it passed out of the House, does make a reference on page 1 on the supplemental note regarding the earnings and the change in paid or language, but that was written after it came out of the House. So anyway, it has been discussed in the sup note, and you then heard the rest of the history from our conferees. I would encourage the conferees, both the proponent and the opponent, to talk after committee today, and otherwise, you heard we did have a question and a request that we would like to have that happen so that the committee can be more informed if we're going to work this bill about what the position of both are. And please communicate with committee members. It's the practice of the committee that once we are finished with a group of conferees that we don't return. So that's where we are, which is why we encourage the proponents and opponents to confer on this and with members of the committee if they so choose. And Senator Baumgardner had another question.
Thank you, Madam Chair. I'm just curious if line 23 on page 15 had been familiar with people, if there might not be more opponent testimony. So do you anticipate that perhaps more groups, garnishment is a big issue in every state, but do you anticipate that perhaps more organizations or groups might want to weigh in on this?
Thank you, Senator. I can't speculate to that. What I would say is this small change in language seems to be a big change in policy.
It does.
And that I'm glad it was brought to the attention of the committee so that we could be fully aware of what the bill does and doesn't do. And I'm looking back at the testimony in the House. There was opponent testimony from the Kansas Association of Criminal Defense Attorneys that I haven't looked at that, but that possibly was on the restitution piece and probably not on this paid or language. I'm not sure. I haven't had a chance to review that testimony. But it is a big policy change, as the senator pointed out, and as the conferee pointed out, and we want to make sure that we fully address that issue, and we may have a subsequent hearing. We are running short on time this session as we approach the end of session, quite frankly. So not certain we will put it on the calendar, but we will take a look at it. And in the meantime, I do encourage those who are stakeholders in this area to please contact committee members so that we can be fully informed about the impact of the bill as written or the bill as proposed to be amended by one of the conferees today. So with that, committee, are there other questions for the opponent conferee? Seeing none, then, want to thank the conferees who appeared today in committee and those following along online watching for your testimony today and bringing this issue to our attention, both on the restitution piece and on the garnishment piece as well. Thank you for that. With that, we will close the hearing on House Bill 2608, and we will then be looking at another full agenda tomorrow. I don't have it pulled up in front of me, but we will be getting out of committee on time today. So want to thank committee's attention and those following along in the committee meeting room and online as well. With that, committee, thank you for your work, and we are adjourned.